Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This is episode 293 of Registry Matters. Good evening, Larry. Good evening, Chance. How are you?
Good. Thank you.
Well, and Chance, are you permanent now, Larry? Is this a permanent addition?
Larry,
it's permanent as long as we can keep Chance.
more than happy to stay. If you guys invite me, I'll be there.
Have you continued to be invited?
Yes.
Because I didn't do it.
No, okay. It was all Larry's fault.
I didn't do it.
All Larry's fault.
So, I believe that.
You have a little thing to play now that we have an additional person here that you can play from the postmaster.
Oh, I do have that one.
How much longer are you planning to stay?
A long time. Get used to me.
And that's Chance now?
No, since we have Chance, you could pose that question to me. How much longer am I planning to stay? So I'm planning to stay a while longer, but I don't know if I could go as far as he went in that clip, though. But I'm planning to stay a while longer, at least through this year.
Well, clip.
All right, perfect.
Stick around, Larry.
Well, make sure that you press like and subscribe and hit that notification bell on YouTube. That helps the algorithm. You all know this. Every YouTuber says, make sure you press the like and subscribe and notification bell, all that fun stuff. You can download the show as a podcast and listen in your favorite podcast app. That's what my preference is. I have like 60 podcast subscriptions, but that's because I'm just a freak of nature on that one. Now, with all of that said, Larry, what are we doing this weekend?
We're all over the map this evening. We have some listener questions, and I really have to commend one of them. It's very creative. We have a case. We have a case from the state of Louisiana, from I forget which federal district court, but it's somewhere, middle district, eastern district, northern district, somewhere. Deals with juvenile PFR issues. And we have a California coroner. It deals with some issues related to hearings, getting off the registry, and some articles that are entertaining. And also, we're going to do a scam warning.
So let's dive right into the scam alert. And this comes from Scott Morgan, who is the Narsau Region 3 coordinator, which is kind of like the center of the United States, kind of west of like Pennsylvania and Georgia, that general region. Illinois Voices is who he is with. And says, I received a call from a guy named Officer Brooks claiming to work for McHenry County Sheriff's Office. He called me at work today and I asked him if it was a joke and he hung up on me. I have called him back a couple of times from another number, and both times he answers the phone, Sheriff's Office. If anyone wants to have fun with him, call him back at, here's the phone number. Please, everyone call him. 815-242-7154. I don't think he's a sheriff. Please don't mention my name, but ask him why he is calling people to harass them. Presumably, he was going to blackmail me, but I didn't let him get that far. The number appears to be a landline in Rockford, Illinois. Does anyone have a subscription to a service that can identify this guy? Oh my God, that's awesome.
So, well, on a serious note, folks, please don't buy into this. If you're in any type of arrearage with your registration obligations, they're not going to let you buy your way out of it. Now, they may call you and give you a courtesy call. I have heard of that, and tell you that if you don't get down to the sheriff's office in person by a certain time, either today or very soon, that they're going to come out and visit you with a warrant in hand. But they're not going to ask you for money to resolve this unofficially, and what they call it, privately. All that stuff, that's nonsensical. I don't go so far as to say I would hang up on them, because there is a slim chance you might be dealing with the real authorities. But if they ask for money, it's kind of like when the person morphs into a minor that starts out as an adult. When they start talking money, at that point, from that point on, anything you do is BS, because the law is not going to ask you for money to work this out privately.
I'm with you, but God, can you imagine if we all just bomb the guy and was calling and just war dialing the guy. Do you remember, Larry, Les Nessman and WKRP with the chickens on the like the library steps or something like that?
I remember the show, but I don't remember that episode.
Oh my God, it was so funny. So there was some, like for Turkey Day, like Thanksgiving or whatever, and they were dropping chickens out of a helicopter. I don't remember the details. I'm sure someone is about to tell me all the details about it. But oh my God, I can just imagine all of us calling this guy just nonstop day and night, harassing the shit out of this guy. That would be amazing.
That would be a turnabout, all right.
Well, let's be careful though when you encourage people to make unwanted telephone calls, even though what he's doing is below the pale. There is a law against making a phone ring repeatedly with no legitimate purpose. I don't want anyone to be charged with harassing or annoying phone calls or anything like that. But it would be funny if you could do it and not be detected, but I would certainly be careful with that. Okay,
so don't wink, wink, nod, nudge, nudge, do it. Don't do it. I'm telling you, don't do it. That's hilarious. Sorry, that's really funny. So all of my stuff had crashed, Larry, and I'm just putting it all back together now. So, all right, we are able to move on now. I'm sorry. And now we can move over to not that window. Holy God, I don't have stuff set up for Larry. I'm so bad at this today.
Yeah, we have a question from Amy, and it's addressed to Larry and Chance. Do you want me to read it?
No, I can get it. I just don't have the screen pulled up to display to the you people. But I'm getting there. I'm almost there. Just give me 1 second, and I'll have it put up there.
While you're looking, I'll describe this question. We're going to have a little bit of a struggle with it because it's extremely long, and I shortened it, and I tried to divide it into a breaking point between the main 2 points of the question. And it really does have 2 central points that she's making. And Amy, we're going to do the best we can, but we really don't have any great answers. But these are great questions, and you put a lot of effort into thinking up, particularly the tail end of it, of the discrimination based on race. That is some pretty creative thinking.
And I will do this just 1 second. Just take a quick breather because something went in the wrong window. Listener question. That's the right window. Perfect. All right. So it says, "Hi, Andy, Larry, and Chance. I have a couple of questions about the Equal Opportunity Commission, EEOC, and how it might apply to our community. And here's a link to the guidelines I have been researching. My husband was convicted of 1 count of possession of CP in '97 in Texas. He moved from Texas to North Carolina and then from North Carolina to South Carolina. He has been removed from the registry and its requirements in South Carolina, where we do live now. He remains on the Texas and North Carolina websites. North Carolina says they will take him off if Texas does, and Texas is denying his petition for removal. Gaining unemployment in the healthcare field has proven to be tough." Is that gaining unemployment or is that gaining employment?
That was a typo I didn't catch in there.
Okay, very good. Just making sure. So it's gaining employment in the healthcare field has proven to be tough. He gets offered positions and then they rescind their offer when the registry check comes back. The same situation happened with his current employer. I read their hiring policy and opened a case with corporate stating that his Fair Credit Reporting Act rights had possibly been violated due to not receiving pre-adverse action notification and adverse action notification. Per this organization's policy, they were to provide both in writing. However, the FCRA, and that was the Fair Credit Reporting Act, the FCRA accepts verbal. He was still denied employment, but corporate said if he was taken off the registry where we live, that he would be eligible to reapply and work for the company. A few weeks later, he received a letter from South Carolina that he had been approved for removal from the South Carolina registry. He applied for another position and could tell immediately that the application was being kicked back. I reached out to corporate again, asking them to remove the block they had on him, and he had been removed from the South Carolina registry. We got everything straightened out, and he was hired. I started researching hiring regulations for people with felonies. I have researched the Equal Opportunity Commission regulations, and I am probably grasping at straws to find something that could work for our community. I trust that Larry will not hold back and give me his honest opinion, not advice. I'll pause here for a chance in Larry. So take it away.
All right. So what she's communicating in that first segment is what the most of the registrants out there don't think that I understand when I say you're listed on the website, and somehow or another they don't think I understand that it can cause you difficulty. But being denied a job, although as horrible as it is not the same thing as being registered. But it certainly is something to not be taken lightly. So I recognize that. And I can concede that it happens, and it did happen. And her persistence is likely what got him over the finish line. She sounded like she was being so diligent and thorough, and corporate probably didn't want to deal with her and any possible consequences because she comes across as being someone who's thorough and possibly litigious. And but on the second part of this, she's come up with a scenario that I could never have imagined in terms of how she wants to change the I guess it's called the not the Fair Credit, but the Equal Employment
EEOC?
Hiring, the protection that people have against discrimination. She wants to have a protected class of people, and she's come up with a scenario that you got to give her credit. It tops the blizzard in Fort Sill by a long shot.
But we're not a protected class, so does this just die right on the doorstep?
I'm afraid so, but yeah, this second half you're going to read, you can see that she's actually come up with something. It is plausible that could happen. It always say you need to come up with something that's plausible. This is actually plausible.
Okay, so I will continue. A covered employer is liable for violating Title 567, Title 7, when the plaintiff demonstrates that it treated him differently because of his race, national origin, or other protected basis. For example, there's a Title VII disparate treatment liability when the evidence shows that a covered employer rejects an African-American applicant based on his criminal record, but hired a similarly situated white applicant with a comparable criminal defense. In this scenario, say a white man has a conviction for possession of CP in South Carolina. He has been on the registry for 25 years. He petitions to come off the registry in South Carolina, and it is granted. He applies for a position, and they run the background check for 10 years. His conviction does not show up, and neither does the registry. On the same date, a black male committed the same offense and was convicted in South Carolina. However, he has been to Florida on vacation for a week. He petitions South Carolina and is removed from the South Carolina registry. Of course, he is now on the website in Florida, even after death. Although he has no legal requirement to register in Florida, pay attention, you people in California, although he has no legal requirement to register in Florida, it shows up on the quote-unquote National Registry background check for employment. He applies for the same position as the white guy we just talked about. Let's say the black male has more years of experience and better qualifies for the position. These two people committed the same crime on the same day in the state where they live in, and one gets removed from the registry. However, even though the black male is more qualified for the position and the white male gets the position because the black male went on vacation to Florida, which that's probably true, Larry.
Well,
go ahead, interject, please, because there's still a lot more to go.
Well, but do you see what I'm saying?
Yes.
Who could have ever thought of this?
I think a lot of us could have thought of it because all you had to do is spend 75 hours, whatever it is, in Florida, and you're on the website, Larry. You're not on the registry. You have no legal obligation. You're not under any threat of prosecution, but you still show up. Had I done that, I've been off the registry now for 3 years now, almost, and I would still be on Florida's website having all that baggage come behind me. I'd like a wedding car with all the cans coming behind it all the time.
So
except
all right, keep going.
Except in Florida, it's not until death do us part. That's the problem with
That's
Florida.
correct.
It's
So we're like married, and it's a bad marriage.
For all eternity is Florida.
All right, now I got to figure out where I left off. Okay, so let's see. These two people committed the same crime. That's where I was. All right, and so, however, at the very least, it should be a requirement that if it will be used for employment, that employer only be able to run it for the state they live in, since the state laws are so inconsistent. I know that people would argue that there are certain positions that people who have been convicted of a PFR type offense are ineligible for, places such as daycare, schools, nursing homes, etc. That being the case, the registry is not a good check for that because in the scenario above, the white male no longer is on any registry, but he was convicted of the offense. Employers of that nature should run background check to the applicant's date of birth to ensure they capture ineligible applicants. If an employer policy is to run a background check, say 7, 10, or even 20 years, that means they believe if someone has not committed a crime in that time frame, they're eligible to work for their organization. That should be no different for our population. I would argue that the registry is discrimination. The Oxford Language Dictionary defines discrimination as the unjust or prejudicial treatment of different categories of people. I would think this is different categories of people, those who are on a registry website versus those who are not. And then, of course, Larry, any thoughts?
I actually agree with Amy. And I was talking to a gentleman that contacted me in the last week or so. And Chance, you and I talked about this guy because he got the communist state of Colorado to release him from registration based on a Texas conviction. And then he wants to go back to the freedom-loving state of Texas that will not release him from the registry obligation because he can't stand the communist state. But he wants to do a challenge of the he wants to do an ex post facto challenge in Texas, and I told him I do not support that. I said you can blow your money if that's what you want to do. I said, but I think you ought to more narrowly focus your challenge on the harm that you've suffered from being on the Texas website because you've got tangible proof. They tried to disembark him from a cruise in 3 different nations because they discovered after the manifest, after the ship was on the cruise, they discovered his condition of being listed on Texas and Illinois, although the communist state of Colorado had granted him termination. And those were his words. That's why I'm saying that. Those were his words. He wants to leave that communist state now that he's off the registry. And I said, well, if you challenge your direct harm, you've got a direct harm here because it would have cost you thousands of dollars of lost cruising expenses, plus whatever thousands it would have cost you. I think Guatemala was one country they tried to kick him off in, another was Belize, and I forgot where else they were trying to disembark him. And another nation, surprisingly, they didn't want him for some reason. And but this would be, in this scenario that Amy describes, this would be for a person would possibly have direct harm that they could associate with a challenge to Texas about continuing. You would file the challenge in Texas saying that there's no rational basis to keep me on your list because I have rehabilitated, whatever arguments you make, I'm no longer required to register, and I haven't been connected to Texas in 27 years now. And you're continuing to harm me. And so if this person, under the scenario that she described, if we could find such a person who actually had those particular facts, I think it might be a worthwhile challenge. What do you think about that, Chance?
Yeah, that's quite possible. Quite possible. Unlikely, probably, but possible. Yeah.
Well, I don't think it would be dismissed on the 12b6 motion right away because if you can show harm, that keeps you in court. You got to show that our system revolves around harm. Everything that's wrong doesn't harm you, but this would be an actual harm, an economic harm.
Yeah, well, I think that's true. Way out of my wheelhouse.
Does this go to court? Does this go to court, or does this go through the legislature?
Oh, well, I think the court would be the impetus to get it to go through the legislature because Texas is not going to stop doing that. And the other states that do it, they're not going to stop doing it. But you would bring a cause of action in Texas showing your genuine economic harm. And you would you would do a petition for declaratory judgment saying that this, either your policy or your state law, and I don't know if it's one or the other, or it could be both, but this violates my right to have gainful employment. You are carrying something that's no longer true. I am not a registered sex offender. Now, if I were to put on the state of Texas's hat, I would say, you're so right. And what we're going to do to fix that is we're going to put in little tiny 8-point font on the registry no longer required to register. and we're going to leave it just the way it is right now. So good luck and go ahead with your suit. I mean, if I can think of that, so can they. But I think that you would not be laughed out of court if you actually have actual harm. And so someone who could prove that they had better qualifications, they were denied a job, and somebody had almost an identical crime, the almost identical years in the past, and they got the job. That's going to be a tough thing to show. But like I say, it was very creative, and I think that it's not laughable in terms of it might gain traction. And then you would use that as leverage to get them to change their policy to stop keeping people listed who are no longer connected to Texas or Florida or wherever the case may be.
Apparently, we need to find a very bored attorney. Do you know any? I'm thinking maybe Chance is bored.
Oh, no. No, Chance isn't bored. No. Not me.
Interesting.
So, all right.
Okay.
So,
well, thank you for being. So Amy is now our hired creative thinking person.
if she can top this, I'll be waiting for it.
All right. Well, Larry, you have a case in here for tonight that is from Louisiana. It's Aaron Nelson. I should have said Aaron Neville. I should have just put that in there just as a flub up on purpose. But it's Aaron Nelson et al. Versus Jeffrey Landry in his official capacity as Attorney General for the state of Louisiana. And et al. Chance, what is et al?
I'll take a shot at this. It means and others. And it's often used in legal documents where multiple individuals in a single party must be noted. It is also used to reference a large group of people. So more than just the people on the title, in this case, are involved.
They use it in scientific papers, and I think it comes out to be the person who's alphabetically first usually ends up to be the first person.
Well, I'm not sure about that. I've always thought it to be that Latin term and others, meaning there's a class depending on this.
And so, Larry, are you even qualified to answer that question?
I would say I'm not qualified, but I would say give a similar answer that it means I've used it in pleadings before, and I believe that would be consistent with what I think it means.
All right. In the opening, it says, this matter comes before the court on plaintiff's motion for partial. Oh, here it is, Larry. Here it is. Partial summary judgment. Larry, I know you love it.
Well, I do love summary judgment when it's used appropriately and when there are no material facts in dispute. And those facts don't need to be fully developed in a trial. In this particular case, summary judgment seems to have been the appropriate vehicle because there doesn't seem to be a lot of material facts in dispute here. This is more an interpretation of the law. But I'm not absolutely positively sure that 28 pages, it was such a difficult read that I gave up on it.
So this case is about Louisiana's PFR registration and notification statutory scheme. In their motion, plaintiffs who committed PFR type offenses as juveniles and are now subject to Louisiana's statutory scheme urge the court to declare various parts of this scheme unconstitutional and enjoin the state from enforcing the same against them. Specifically, plaintiffs challenge, number one, Louisiana's requirement that PFR's driver's licenses be branded with the phrase PFR. Number two, Louisiana's requirements that registered PFR's identification cards be branded with the phrase PFR. And number three, Louisiana's social media ban for PFRs. That sounds pretty nasty, and I'd like to see if Larry can concede that these requirements are unconstitutional.
I can say that they have a powerful case to make because there was a case in Louisiana from the state Supreme Court that dealt with the markings, and I think it was the Hill case. It was referenced in this opinion. But they're already on shaky ground because they have the highest court of the state saying you can't do this. In terms of the social media ban, I think that we already have a fair amount of guidance on that in terms of the case from North Carolina called Packingham. So I think I can concede that they're a weak territory with what they're doing in Louisiana. But why are you surprised? It is Louisiana. It's like that whole Bible Belt is so forgiving. This is common stuff for Louisiana, Alabama, Mississippi.
Louisiana is one of the worst ones as far as like death penalty stuff or life imprisonment kind of things. At least in my mind, from whatever we've covered and whatever I've heard, they are just awful. Angola, right? That's in Louisiana. God. Yep. All right. Well, the plaintiffs began by asserting that under Louisiana, what is RS? Something statute. What is RS?
I'm guessing revised statutes.
That's probably
okay. Very good.
Probably right. That's probably right.
Okay. So Louisiana's revised statute, and that's section 40.1321, paragraph J. I don't know. Those are required to register, regardless of the date of their conviction, must obtain and carry an identification card from the... What? All right. They must carry an identification card from the Department of Corrections that contains the words, the ones I've been screaming so far, PFR. Likewise, under Louisiana's revised statute 13 and then 421 paragraph 1, I don't know. Those who are required to register regardless of the date of their conviction must have the words aforementioned PFR in orange on their driver's license. What is ID at 6? What does that mean?
It was should have been omitted, but when you do the id, it means the preceding citation carries over. So what you've just spoken to previously, you're rather than having to write it out again, that's all that does.
Okay. And then, so continuing, plaintiffs argue that since both statutes apply to registrants regardless of the date of the registrant's conviction, and A, juvenile adjudication is not a conviction of any crime, these statutes do not apply to plaintiffs who are delinquents adjudicated in juvenile court. And the same thing you just said about citing any number of cases that I'm not going to read. What do you think of their argument?
Well, based on the fact that there's already state Supreme Court precedent, and they have that dual requirement in Louisiana, and the ID card and the driver's license. I believe that Hill case was decided on driver's licenses, but I'm surprised that it's taken this long, because when the state Supreme Court says our registry has infirmaries, the state said that they would voluntarily stop enforcing the motor vehicles, quit putting the PFR on the licenses, and now I think they have a code, but apparently they didn't do anything about the identification card. But I'm surprised it took this long.
Chance, do you have anything to add from there?
Well, it's a partial victory, and the court granted some of the relief requested, but it seems to me that it did a pretty good job in almost granting all of it. But still, it's partial, and I can go through those things if you'd like me to.
Yeah, that would be great if you could, because you'll be able to read the statutes way better than I can.
I don't know about that, but I'll be happy to do it. First, the court declares that Louisiana's statute, section 32.412, sub 1, Louisiana's requirement that registered sex offenders' driver's licenses be branded with the phrase sex offender, that's unconstitutional, and it enjoins all defendants from enforcing it. That's the first thing. As to plaintiffs' Louisiana revised statute section 1321 sub 1 claim, that's a lot to say. But anyways, that's challenging Louisiana's requirement that registered sex offenders' identification cards be branded with the phrase sex offender. To that claim, plaintiffs moved and denies that part of plaintiff's motion dismissing plaintiff's Louisiana, again, section 41 or 1321J claim without prejudice. What does that really mean? One, that's the denial in part, so they don't get a total victory, but without prejudice means they can come back and do it again. And then the third thing to note is that it declares Louisiana's revised statute section 1491.5.5, Louisiana's social media for registered sex offenders, inapplicable to adjudicated juvenile delinquents. So, if you look at it contextually, it is quite a victory. I mean, what they denied in part, well, that can be fixed and resought, but the rest of it they got. So that's pretty good.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Something that comes to my mind is we sort of have a split decision of what they did. So Alabama had the driver's license marking turned away, and Florida has one, but it's really, from what I have seen of it, and I saw one in person, it's pretty benign. But the Oklahoma one is pretty horrid. So this would fall in line with what Oklahoma has, but it got turned away in Alabama. The victory was ours in Alabama that they couldn't write this on the driver's license. So where does a split decision like that come down when it goes to court?
Larry, where's Larry?
I'm not sure I understand the question when you say a split decision. What do you mean by that?
What I mean is that Alabama, they were going to put like freaking giant neon-sized letters on the driver's license saying PFR, and then Oklahoma has something fairly obvious. I can't remember exactly what it is on theirs that says that you're a PFR. So you have one state that has driver's license very clearly marked, and you have one that it was it lost in court of putting them on the driver's license, as in we won to keep them off the driver's license.
Well,
so when you have that split.
Well, when you say split, that normally you're indicating something that I don't think applies here, because these are state Supreme Court rulings, and one state's not bound by what another state Supreme Court does.
Yep, you're correct. I agree.
You could argue it's persuasive authority. You would, if it supports your position, you would say what a brilliantly well-written, well-reasoned decision. I mean, you would just embellish it beyond all imagination. You would cite to it, but it's not binding. But the markings in driver's licenses, you can mark driver's licenses. I keep saying that, and I'll get hate mail for this. You can mark driver's licenses, but we have to mark driver's licenses like we do everything else. When we force people to speak, we have to give people the opportunity to address that speaking and see if that's something that needs to be spoken. But we can force you to speak if you have a communicable disease to keep the public safe. We can force you to do that. We can force you to speak if you're running a restaurant. If you're running an unsafe restaurant and you're downgraded, we can force you to speak that. And we can force you to speak on your driver's license if you have visual needs that make you an unsafe driver. But in all those instances, you've had an individualized determination that you need to speak that for the public safety. In the case of putting markings on people's driver's licenses, they've merely been given a categorical designation that they've been convicted of a PFR offense, which is a voluminous list in most states. And that is no individualized determination if the public safety needs that speaking to be done. But absolutely, if you gave people due process and you narrowed down whose licenses got marked and how they were marked, you could force people to speak. We force you to speak with an interlock license. Here in New Mexico, when you get a DWI, we force you to speak that while you are serving your sentence. You have to have a special license. We can force you to speak, but you've had an individualized determination. In this instance, these states just go so crazy putting this stuff. Everybody has to do this. And if they would just narrowly tailor it and give people a process, if you go to the motor vehicles and you have LASIK surgery and you no longer need visual corrective lenses, and you go in and say, look, I want to take an eye test today because I don't need to have this speaking on my license anymore because I can drive just fine with regular eyesight. They put you up to the scope. You read the letters without corrective lenses. They will issue you a new license without you having that requirement that you have the corrective lenses.
I'm trying to, in my brain, that we have the PFR civil regulatory scheme and we have driver's licenses. That's a civil regulatory scheme. If it's a factual statement about what is in the past, isn't that like you're 17? That's a factual statement. So now you have to turn your driver's license sideways, or you have a different color background than everyone else. So it's clearly that you're a minor. Isn't this similar?
It's similar, but only remotely similar, because the speaking that we're forcing you to do is implying a danger.
Okay.
Your driver's license, when you hand it in to somebody and it says sexual offender, the public safety that they're articulating, this is enhancing public safety because people who encounter you, particularly law enforcement, they need to know these sorts of things. And to me, that's a weak claim because if you're registered as a PFR, the law enforcement knows you or that you're registered, or as soon as they run the NCIC, they're going to know because you're in the NCIC as an actively registered person. But in terms of, it's not a historical accounting. It's to me, it's a different connection, but I can see your logic.
Yeah, I appreciate the way that you word that. Plus, I don't imagine that very many PFRs are going to like spontaneously offend against a cop upon some sort of traffic citation.
Well, it's not just that you might spontaneously offend against the cop. It might be that the situation you're in would be more thoroughly investigated if they knew that information, that you were actively registered. But I'm saying they can get that information anyway. If you're by a high school ball field and you've got a pair of high-powered binoculars and you're sitting there with a blanket over you, and the officer comes up to your window and says, "What are you doing?" and he runs your license and you're on the active registered list and you're watching the teen athletes with binoculars, that would probably be justified to ask a few more questions.
Fair. But he would have found that out by running you in the computer anyway.
That's correct. And that's why I'm saying this is totally unnecessary. But just because something is totally unnecessary doesn't mean you can't do it. As long as you narrowly tailor it and you can narrow this down to such a small group of people and have due process. Law enforcement, listen to me carefully. You can do a lot of stuff as long as you narrowly tailor it and give people due process so that they can undo it.
Yeah.
And if you'll follow my advice, you can get away with a lot of things.
That's absolutely true. Absolutely true.
Well, let's continue though. Go ahead, go, Larry. I don't want to interrupt.
Well, it's bizarre that they don't think that way because narrowly tailoring, you put somebody on probation supervision, you can almost deprive them of every single right that they have because they're being punished. But it has to be narrowly tailored and related to that offender and those particular factors of that offense. You might tell a person things that you could never tell the population, the supervised offender base as a whole, but you can tell them, sorry, we're going to monitor every phone call you make. Your phone must have an individual printout of all your calling. But you can only do that to a person who has telephone problems. You couldn't do that to the population at large, but you can get away with almost anything if you narrowly tailor it.
I noticed at the end the following. Plaintiffs also argue that plaintiff's statement of uncontested material facts should be deemed admitted as to defendants DOC, LSP, OMV, and BCII, since none of those defendants responded to plaintiff's motion. Since these defendants did not oppose plaintiff's motion, plaintiff's statements of uncontested material facts are deemed admitted as to these defendants. Further, since these defendants did not oppose plaintiff's motion, this court's ruling is deemed binding as to these defendants as well. Holy moly, Larry, that is a lot of talking in circles the way that it sounded to me. I don't know what those acronyms are, and there's a lot of plaintiff's motion and plaintiff statements and all that. So anyway, what does this mean? Please tell me, Chance, please.
Well, I want to initially say, I mean, it's like they're all married to the plaintiff's statement of uncontested material facts. I mean, there's nothing more to consider on the issue because they didn't submit anything. But more interesting than my take would be Larry's, because this is Larry's thing right here. This is Larry's thing. Larry, tell us about this.
So, well, I get very irritated about facts, and there's several ways you can get facts into the record. And one of the ways is you can file. I'm having a senior moment, but you can file something. And if the party doesn't dispute it, it's deemed admitted. You can require a request for admission. I think it's what it's called. Help me out here, Chance. You can file a request for admission.
Right.
And if the opposing party doesn't respond to that in a certain amount of time under the court rules in our state, those requests for admissions are deemed admitted. And that's kind of what we have here. We have facts that were established by those various agencies. I'm assuming DOC's Department of Corrections. I don't know what LSP is, but I bet it's something Louisiana State Police. And the OMB is probably Office of Motor Vehicles, and I don't know what the other one is. But all those defendant parties in that et al. Category, they didn't respond to these requests for these material facts. So therefore, they were established as facts. This is now the law of this case. This is the law of the case. This cannot be easily disturbed. If this goes up to the Fifth Circuit, these facts are there.
Exactly.
So, to word it a different way, though, is this like they asked for their response and they didn't get it, so they just timed out? Therefore, by default, what was there already takes precedence? And that's not the right word.
No, I think,
Yes,
I think the
like
right
say
way
you-
to think about it, Andy, is if you snooze, you lose.
That's fair. That's fine. Yeah. That works.
So,
Interesting.
you file, like I say, you file a request for admission, and they don't respond, and so you ask the judge. Now here it is accompanied by a motion to deem those admitted. But in this particular case, it doesn't look like that motion happened. It looks like that just by snoozing that they lost and that they were deemed admitted. But this is now the law of the case.
Interesting. And so you always rail on summary judgment, and here we get to throw pies in your face because it worked for us.
Because of the uniqueness of this case. That doesn't
Yes.
make me a fan of summary judgment all of a sudden. I'm a fan of it when it's appropriate.
Anything else before we then go over to the California corner? Dun 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 dun.
Come on
Oh,
down.
let's do this,
Come
'cause
on down.
This will get me off the hook for a while because I don't know squat about California.
Okay, well,
Well, please take it away, Mr. Chance.
all right, good. 'Cause it's just an extension of what we've been talking about. I mean, we talked about, the process of petitioning, and we talk about some snags in the petitioning process. But, what happens when there's opposition? What happens when the prosecutor objects to your petition? What happens next? And this is the logical progression. So this is the petitioning process, actually, part 2, in an effort to demystify the hearing process. So if, the standard governing registry termination petitions is Penal Code Section 290.5A3. Section 290.5 requires the court to determine, based upon evidence presented by the district attorney, whether the community safety would be significantly enhanced by requiring continual registration or continuing registration or continued registration. Let's be more clear. Now, the purpose and language of the tiered registry law indicate the legislative determination that a person who has served his or her minimum registration period or longer should be relieved of the duty to register, unless evidence demonstrates that the individual possesses a significant risk of reoffense. And that is something that's so important in California, because that's really where risk comes into play. Now, specifically, the Penal Code section that we're talking about here is 290.5A3, which provides that if the district attorney objects to the petition for termination from the sex offender registry and requests a hearing, well, if they object, you're going to get a hearing, usually, unless it's based on eligibility and it's an objective factor. So if they object and request a hearing, the district attorney shall be entitled to present evidence regarding whether community safety would be significantly enhanced by requiring continued registration. Any judicial determination made pursuant to the section may be heard and determined upon declarations, affidavits, police reports, and any other evidence submitted by the parties which is reliable, material, and relevant. So one might ask, so who has the burden of proving that evidence demonstrates that the individual possesses a significant risk of reoffense? Well, we got that answer last April in a case called Ty. The Court of Appeal in People v. Ty, which is a 2023 case, and it can be found, and for all you folks who want to read it, 90 Cal App 5th, 427, or 307 Cal Reporter 3rd, 178. And it interpreted the standard to mean that the prosecution has the burden to prove evidence that the petitioner is currently likely to reoffend. Okay, so it establishes that the prosecution, has the burden to prove this. The prosecution's burden for continued registration includes 7 mandatory considerations to guide the court's evidentiary determination as to whether community safety would be significantly enhanced by continued registration. And these are the factors, but I'll go through these, but there's really just one important one. But the first one is the nature and facts of the registrable offense. The second one is the age and numbers of victims. 3, whether any victim was a stranger at the time of the offense, which means known to the offender for less than, say, 24 hours. 4, criminal and relevant non-criminal behavior before and after the conviction for the registrable offense. And I think that's common sense. What, any crimes, any sex crimes committed before or after. Let's see. And number 5, the time period during which the person has not reoffended. That's a big one. The successful completion, if any, of a Sex Offender Management Board certified sex offender treatment program. And 7, the person's current risk of sexual or violent reoffense, including the person's risk levels on the Sorazzo static, dynamic, and violence risk assessment instruments. For our purposes and for thinking about this particular issue, of all of these factors, the most important is the nature and facts of the registrable offense. And the reason why is because the prosecution almost always objects to granting the petition and requests a hearing solely based upon the nature and facts of the offense. Because of the plain text of the Registry of California's tiered registry law, as well as the Second Appellate District's ruling in People v. Ty, they confirm that continued registration cannot be based on that justification alone. You can't just base it on the facts and circumstances of the case. Continued registration is warranted only when the facts of the offense, combined with other statutory considerations in Penal Code Section 295A3, which I just went through, presented empirically, which is a proven, grounded reason to conclude that the individual is currently likely to reoffend, and that continued registration would significantly reduce the risk of reoffense. And that comes from Ty. So let's put this in perspective. In this hearing, the prosecution's burden is incredibly difficult to carry if a registrant is not reoffended. It's about as simple as that. And let me give you a case in point, and that is the Ty case. And it's so helpful to understand. In Ty, the petitioner filed a petition for termination of sex offender registration 24 years after his conviction for violating Penal Code Section 288A. The petitioner had not reoffended since his conviction, which is a big fact, and the prosecution's evidence consisted of solely of various exhibits dating from the time of the offense, which means they were relying on the facts and circumstances of the case 24 years ago. The prosecution argued that Ty's conduct itself was sufficient to conclude community safety would be significantly enhanced by his continued registration, because the facts of the offense were particularly egregious in this case. That's what they argued. They said adult Ty took complete advantage of a 12-year-old doe. Ty preyed upon this familiar doe. Also, Ty had 2 misdemeanor convictions for selling alcohol to minors that predated the underlying offense, but he had not suffered any convictions since then. So for 24 years, he had had pristine conduct. They also said that Ty's statements after the underlying offense, which was 24 years ago, demonstrated that he lacked remorse and that he felt treatment was unnecessary, and that it did not appear that Ty had completed any sex offender treatment program. I don't think there was any effect at the time. So based upon evidence presented by all parties in Ty, the appeal held that the prosecution failed its burden to produce evidence establishing that terminating the registration requirement considerably raised the threat to society because 64-year-old Ty was currently likely to reoffend. They didn't establish that. Specifically, other than the evidence of the 24-year-old underlying offense, the prosecution offered no evidence that Ty presents a danger today. Indeed, the evidence demonstrates the opposite, and this is what the court said. For almost 24 years, Ty has not suffered any conviction. Most notably, the Court of Appeal in Ty noted that the trial court's singular focus on the facts of the underlying offense did not demonstrate Ty was a risk to the community over 24 years later. So here's the point and the conclusion. The hearing, if you're going to have a hearing, is all about a registrant's current risk of reoffense. If the prosecution cannot prove that you pose a current risk of reoffense, the court must grant your petition to terminate registration. And that is what makes California distinctive from just about any other state in the union. Questions?
Congratulations on that, because I never fully understood that. I had a bias against the removal process because I don't like a process where victims are able to participate. And so notably in cases we've covered, that's in fact what happens. They either participate by showing up or they participate by sending a letter that the prosecutor reads. But in section 2A above, it says any judicial determination made pursuant to this section may be heard and determined upon declarations, affidavits, police reports, and other evidence submitted by the parties, which is reliable, material, and relevant. I interpret that fairly broadly. So what stops them from using police reports from 24 years ago? What stops them from using the parties from 24 years ago? Because if the party comes in and it says, loosely interpreted, parties and reliable material evidence that might be relevant, what precludes them from bringing these people in under that language?
Well, actually, Larry, nothing. It can come in, and it often does come in terms of exhibits attached to the objection. But courts have interpreted this law as a window, and that window starts at the date that you're convicted, and it extends to the date that you petition and end up at court. It's that window that's really the focus. And so, it's what's happened within that window. If for instance, you revisited people who are alleged to be victims in the case, if you've picked up other sex crimes, if you have failed to register, whatever happens within that window is game, and then you can start to work down those factors. But let's just start from the obvious. If a person has had pristine conduct and there's nothing within that window to bring forth in terms of establishing that a person is a current risk, there's just next to nothing that can be offered over.
So it can come in, but the Thai case so limits it, is I think it's what I'm hearing you say, because of the interpretation in Thai, that the focus is from registration going forward, not from registration going backwards.
That is correct. And when this thing first, when the tiered system first appeared on the scene, and even before it was implemented, I was always worried because the initial drafts didn't have facts and circumstances of the underlying case, nor, it had a few factors to be considered. It grew in essence. And the one I was most worried about was the facts and circumstances, because every single case has egregious facts and circumstances. And that would mean that any petition based on the facts and circumstances of the case could be denied. I've always read the law to be consistent with what Thai says, and Thai just does a beautiful job of interpreting it, and saying exactly where the burden is. Because often when we first started these hearings, the first thing the government would try to do is shift the burden over to the petitioner. This does not allow for that, which makes it it makes it a much better hearing, and the focus then becomes current risk, and that's what these hearings should do. They should address whether a person is a current risk, and Thai goes a long way in helping that.
I agree, and I was just reading that case we talked about in Louisiana. I didn't get into that part because it wasn't really relevant for the point, but the juveniles can petition to be relieved of obligation after 25 years. But it makes it clearer that the burden is by clear and convincing evidence on the registrant, on the juvenile registrant. And that is quite the opposite of what you're describing here in California. So you guys have got a much better system than what I thought, because my bias is against any petition process. I want people to simply time out. That's the most simple, straightforward process that can be invented.
Well, yeah, and I really agree with you on that. I I mean, if there's nothing in between, they really should. But, short of that, I think the best thing that's going in the United States today is this process as it's starting to shape up. It's not just the statutory law, but it's the case law that's coming down that's just incredible.
So, well, we've got an article to cover too, and I'm going to carry one over. But do you want to get into this Ninth Circuit thing about defense attorneys' access to victims, or are you up for that, or we want to carry it over as well?
Yeah, probably should.
If you're asking me, I'm good, but we can certainly carry it over.
Yeah, I don't mind carrying it over. I mean, I'm not sure we have a whole lot of time to discuss it. It's like, but.
So, well, let's just carry this stuff over. We're getting near an hour now, and we have an announcement to make. There won't be a podcast recorded this coming week. So we have travel and conflicting schedules, and all of us won't be able to get together next Saturday. So we'll be off the air for a week and be returning in 2 weeks. So we'll have hopefully a piece of legislation to dissect and talk about from West Virginia, and one or two of these articles that we didn't get to tonight. What else, Andy, do you have on your radar?
Oh, I would definitely like to have something to talk about from Florida about something with having transposed letters. God, if we could get that would be phenomenal. If you get violated on your registry for using like a 1 instead of an I instead of a 1, or vice versa, and that causes you to go back to prison because like maybe you mistyped it on the keyboard. I don't even know how that would work. That just came across my radar, and that just sounds absolutely diabolical.
Well, now you've got to remember that Florida is a fiscally responsible state, and they do not spend money unnecessarily at all. So they would never incarcerate a person for just simply making a typo. Why are you scaring people about stuff like that?
It's because their governor is self-conscious about being short and has to put little risers in his boots.
I see.
Yeah,
So,
I heard about that.
I do. We did get 2 new patrons, Larry. I sent you over screenshots on their stimulus money, and it was Robert and Daniel. And thank you both so very much. I just was looking through, Larry, that we have one of them is joining us here tonight. He's been a patron since June of 2018.
Well, you need to disconnect that person. He's been around way too long.
And he just says, no podcast next week. He's quitting.
Wow.
Uh-oh.
I know, that's harsh. That's how it is around here, man. It's brutal. So, anywho, any closing words before I take us out of here?
So, well, I'm looking forward to next week of the dissecting a piece of legislation that's going to be working its way through West Virginia, and it's an AWA compliant measure, so that should be fun.
Yes, I'm sure. Chance, do you have any really exciting cases in the next 2 weeks?
I do. I have one I think that needs to be litigated. I'm ready to go to trial on it. I think we'll be doing it next week. It's in a failure to register case involving someone who was out of state and could deregister in California. It's going to be fascinating. I will be happy to talk about it once we're done. It's exciting.
That would be awesome. If you can bring those, I think Larry would also appreciate them. If you can bring us certain, definitely like interesting nuggets of cases that come across your desk, that would be so much fun to talk about.
I'm more than happy to do it.
Fantastic. Well, very well. So make sure you head over to registrymatters.co for getting the podcast. You can subscribe there, or you can listen to it right there on the website. Leave voicemail 747-227-4477 and leave email. No one ever does anymore. registrymatterscast@gmail.com. I guess that's not true because some people sent them, and I always forward them over to Larry and Chance these days. And please support the podcast over at patreon.com/registrymatters. It's very helpful, even for $1 a month. It helps make the podcast that we appreciate it, and we can announce your name just like I did for Robert and Daniel above. And without anything else, I hope everybody has a great rest of your weekend. Have a nice week off, and not Steve. I guess we'll talk to you some other time because you're leaving us. But thank you, Larry and Chance. I hope you have a great weekend.
Thank you.
Good night.
You've been listening to FYP.